Good morning. Today, my name is Mark Ramos, and I'm part of the Education Committee. And today, Meet and Learn 2024, Understanding the Preliminary Title Report for Buyers and Sellers. Today, we have Mr. Joe Haggerty, Orange Coast Title Company. Joe Haggerty is a San Gabriel Valley native and has worked in the title industry since 2003. His experience and knowledge as a title rep comes from working various positions within title companies prior to going into sales in 2013. He enjoys basketball with friends, playing guitar, gardening, cooking, and his free time. Joe has two sons, one in high school and the other in college. His kids are his why in terms of his success, and believes in making sure consumers are treated with the most respect and fairness. So please give a hand to Mr. Joe Haggerty.
Hey everyone, thank you. So very official. Thank you for that introduction. I want to thank everyone who's online participating with us today. We will share the manuscript or the attachment later. You guys can follow along in the presentation, however we can send it out to you later. Before I get into the presentation, I just want to say a little bit about, the preliminary title report. What is it? And, when do you need a preliminary title report? Okay. Because some agents are coming to title reps and just saying they need a preliminary title report, or just very vaguely a title report. And there's a couple different types of reports that you can get. If you're working on maybe a listing presentation, or working on maybe writing an offer on a property, we have what we call a property profile. And the property profile is good enough to prove who was the owner of the property, or show you the recorded deeds and the recorded liens against the property, the specific property, and other property details, characteristics. And that report, that's something that you can get anytime from us, typically with absolutely no cost. However, the preliminary title report is generally only needed for certain situations. And so a couple of situations aside from a transaction might be that someone is maybe doing some construction on their house, adding a ADU, or adding square footage to the home. Often the city or the county will ask for a preliminary title report that is recently dated. So you couldn't go back and get your title policy because it may be already a few years old or longer. And a preliminary title report can be sold to you. I'm not going to get into pricing, obviously, but if that's something you ever needed to have a prelim for something like that, you could call me. If you needed, other reasons could be maybe you're going to court for some reason. There is some type of, maybe there's a divorce, or there's a probate, or there's some dispute with the property. And often a preliminary title report is needed because it'll reflect what's needed in a more official way. And so your attorney might request a prelim and you may have to pay for it. But generally, a preliminary title report is needed when you're in escrow. Why we call it preliminary is because it's going to reflect what we find of record at the time, but there could be things that get added to it after review of the seller's supporting documents, or even physical inspection of the property. Sometimes the title company goes out and actually takes pictures of the property and looks for boundary discrepancies. It's all case by case. Most transactions don't require physical inspection, but there are times where title companies send someone out and you may never notice unless it's a private community and we have to ask for access. Because it's often just a drive-by, something in front of the house, right? So the prelim is needed only really when you're in escrow in most cases. And so then when do you order a preliminary title report? Most people order the report as soon as they open escrow. But however, if you're like a listing agent, you may want to order the report ahead of time. Definitely in some circumstances where the seller may have some some, concerning issues with the property. Maybe you're looking to see if there's some kinds of liens. Um, it may be good to get it, but if you don't know the property is going to sell or may take a really long time to sell, for the title company's sake, we may not, it may not be good to get a report right away. We can always do the research with a property profile and show you what you need to know. So it's all case by case, but generally it's needed right when escrow is opened. So I'm gonna go start getting into it. So if you've attended this class before, that's great. You can always, there's always something new to learn every time. And there are some things changing here and there. So the first thing about when you're looking at a preliminary title report, and if anyone has questions throughout the presentation, feel free to drop them in the chat. I can't take too much time in between, but we'll also answer questions at the end. But if you have a question that's based on something I'm talking about, feel free to drop it in the chat and I'll try to answer it through the presentation. So first, this first page may seem like something to just skip through. It's not a big deal. It's true, there's not a ton of important information here, but first you're gonna see, I have it numbered here, number one, it's typically, the report's typically gonna be addressed to the person who ordered it. Maybe it's the agent, maybe it's the escrow company. If you still see a real estate agent addressed on the prelim, it means they ordered it before opening escrow. And it may also mean that the report is not updated correctly for your transaction. Sometimes it's ordered months before. And then, of course, it's attention to your escrow officer. And then you have the property address below that. Now, the property address, make sure it matches your property. If there's multiple lots, make sure it addresses that there's plus like maybe vacant land going with it. But definitely check to make sure it's the correct property because some properties have similar addresses and you want to make sure you got the right report. And then number 3 and 4 here, you have your escrow reference number and your title reference number, right? So anytime you're calling into escrow or title, it's good to have these reference numbers readily available. It'll get them to look at your file quicker. So when you're calling, sometimes, yeah, the address is enough, but if you have these numbers and referencing them in an email to the escrow, referencing the escrow number is good. We appreciate these things just because it helps us organize our emails. So, just something to consider if you're a buyer or a seller side. And then number 5, we have like a disclaimer from the title company about the matters being shown in the report, what type of policy we may be proposing to ensure. Number 6, the report may show that it was amended or it may not. And so if it was amended, you may ask questions as to why it was amended, what was cleaned up. That's up to you. But generally, the report is a current condition of title as of, and then we have this date right here, right? So number 7, it says dated as of, and this is probably the most important feature on the first page. This is how current the records are shown. So if you are in escrow, it's kind of like how they say there's things you shouldn't do when you're a buyer. You shouldn't get a car loan. You shouldn't do all these things. You also shouldn't record things to your property. Let's say you paid off a lien and you're supposed to record the release of lien or reconveyance, or maybe you're changing who's on title because you want to sell it under a different name or a different entity. Don't ever let your clients do that on their own. Make sure you coordinate that with, that they coordinate it through you and your escrow and title that you're working with. Because as you can see, there's a date here on the bottom that says January 14th. And then up on the top, there's another date, January 21st. That's when the date was created. There's always this gap period. And we may not be able to show everything unless we can see it in our digital records that are about a week behind in Los Angeles County. And then, of course, you have the title officer's name. If you did need to call in and ask about the report, you might want to ask for that title officer. Moving on to the next section of the page, Schedule A. This is definitely more important for the listing agent to look at this right away when you get the report. First of all, it says the property is a fee. So most properties are going to be a fee. It could be a fee or a leasehold type of property generally. There's other types of ways of ownership, but generally you're only going to see a fee or sometimes a leasehold. If it's a condo, it may say a fee plus something like a leasehold. Right after that, you have the ownership. And this is where if you're the listing agent, you really want to look closely at this. In this report, it shows the property is held under a trust, but what you're looking for is this subject to, if it ever says like subject to a paragraph, another item in the report, that means that there's been deeds recorded without title insurance, without, they weren't recorded during an escrow transaction. And they may need to be, we may need to require that a notary goes out again. And I'll get into that as I get down into the report. I'll show you how we will reflect like these uninsured deeds. Okay. We also have the legal description here and the parcel number. Again, make sure that if you're purchasing multiple properties, that this parcel number matches correctly. Everything on this page, this legal description and this parcel number is going to transfer over to the deed, because generally escrow is going to take it exactly as it shows on this report and put it on the new deed to the buyer. So make sure everything is there when you're purchasing multiple properties at once. Schedule B, the next section of the report, this is where we show everything affecting the property before close of escrow. And it always starts with the taxes, the property taxes on the property. So as you can see here, item 1 is the basic property taxes that are due. And it's another thing that to consider paying property taxes right when you're getting into escrow or right before getting into escrow. This also could take time to show updated online. If you sent in a check or paid by credit card directly to the tax collector right around the time you open escrow, we may not see it. We may not see it for several weeks. And in some cases, if it's extraordinary, the title company may want to hold money to make sure that it was paid before we give the rest of the proceeds out. So also for anything like a refinance or a sale of a property, if you're going to pay property taxes around the time, you may want to discuss with title and escrow, because they may want you to pay it through escrow. They may, if the title company makes the payments for you, they can clear it up right away. So paying taxes, another thing to make sure you review. And by the way, does everyone hear me, or do I need to lean in more? Because on the Zoom, hope you guys hear me. If anyone's not hearing me too clearly, let me know. Try to get closer to this mic. The second part is showing delinquent taxes. And there's previous years that you're delinquent on. So whenever you have an entire year from the previous years that's unpaid, or even just one installment that's not paid, those installments are going up monthly. So every month you're getting penalties. And so we show 3 months ahead, and we'll be checking it right before we close escrow. If your clients are typically buyers, they see any type of lien on the property, they're concerned that they're going to have to pay for it, or oh, this looks really bad. Buyers don't need to worry. It's all in your contract that says like who's going to pay for what. So just make sure that that you address this. So another thing I should say is when you're in escrow and you get your escrow instructions as a buyer, you are asked to approve the preliminary title report. And that's where you should list all the things that you don't want to show on your policy, which is this year's taxes that are unpaid, and any types of liens that come up that we'll get into in a sec. This obviously this can affect your seller. If there's unpaid taxes, this is going to change how much proceeds they're going to get. So you may look at this ahead of time. Number 3, we show a lien for supplemental taxes, and it's not showing anything yet, but it's just saying that there will be a future bill coming up. And we are letting you know it's going to be reflected on the policy. So you're taking the property subject to the future liens that come about based on your purchase. Number 4, it's saying assessments and other matters contained in documents entitled Payment of Contractual Assessment required. Notice of assessment. This is referring to this is actually referring to, in the property taxes, there are sometimes liens called hero or pace. The pace or hero program, these are like to make properties more energy efficient, or adding, windows, solar panels, proper insulation. And the state has a program where you can borrow the money to pay a contractor, but the money, the lien gets added to your property tax bill. So if your client does have this type of lien, like if you see solar panels on the roof, or you know that they did some kind of work like this, it's good to get maybe either the prelim or just a clear tax bill that lists everything, so that you can start looking into how we're going to clear that up in escrow. In many cases, if you have a solar lien, the buyer needs to sometimes assist, I'm sorry, the seller needs to assist with getting a payoff demand in some cases. And also the buyer may need to accept the contract if they're not going to pay it off in that escrow, and that can extend the escrow timeline. So it's just something to look out for and address right away. We have a question. Yeah, so we have a question. How easy is it to transfer from the seller to the buyer this type of lien? It's just a matter of similar to the loan process. Like if there's a significant amount and they have to be able to pay their property taxes and their mortgage, they're going to want to make sure that the buyer has the ability to repay that. But if it's already built into the property taxes, in most cases, the buyers are going to want to pay this off because it increases their taxes so much. It often doubles it. But for that specific scenario, you'd probably want to ask an escrow officer, because they're responsible for, helping people to apply and get that approved. I don't have experience in having someone transfer this contract over, so it's hard for me to give you a clear answer on that. I just know that it's something that you should be addressing right away to make sure that the buyer does not want it. It needs to be paid. We need a demand right away. I had a client who bought a house, and they did not pay off that lien, even though they said they were going to pay it on. And it does probably take about 2 weeks to get a payoff demand. On the next page, so item 5, item 6, these are easements, right? So if this is more for the buyer, if you're a buyer looking at the report and you see any type of easements, you should ask for what we call plotted easements. In most cases, they're really easy to see where the easements are. Like on this one, it says the northeasterly 5 feet of the southeasterly 5 feet. I know that probably sounds like another language to most of you, but most utility easements are along 5 feet along the side of a property, or the rear of the property, for the utility company to maintain the electrical poles if it's above ground electrical, and so on. But if you ever see several easements and you know that your client wants to do something like build an ADU in their backyard or do any types of addition, it's good to know where these easements are. And another thing I should say about easements is if you see an easement in Schedule B, like we're seeing it here, it means that it's adversely affecting the property. It's benefiting someone else. But if you do see an easement up here in Schedule A, where I was before, you have the legal description of the property right here. If there's an easement listed here, that means it's benefiting you as the owner. So if you were unsure if there was access to the property, if it's behind another property, or anything that any type of easement you would need to get to your property, it should be listed here, and it should always be shown on all deeds going forward whenever there's an easement benefiting one property. And what is an easement? It's really it's not a means of ownership, but it's really just a means of allowing someone else to access the property. And it obviously, you cannot build over an easement because it could get in the way of somebody accessing that part of the property. So there's different types of easements, and the most common are these utility easements, but often they are a driveway to get through another property to yours, or sometimes there's easements for hiking trails and if you're in the mountains. So it's just good to look closely at those easements, and it's just a good thing to have for your buyer in the future to and highlight exactly where the easements are so that you know exactly where they are. Number 7 is covenants, conditions, and restrictions. So you don't always have, most people think that they're only going to show up on when you have a condo or a private community, but obviously we can see that there are, if you do a lot of real estate, you'll see that CCNRs are in residential, like single family areas, and often they're very old, and they have lots of language that is no longer relevant. We always have this code here that says, you know, if this document contains any restrictions based on race, color, religion, sex, familial status, etc., all these things, they're just letting you know that the laws for civil rights have superseded anything that may show in that way. And there's even a newer law that allows you to remove restrictive covenants, because some people, even though they're not carrying their effect anymore, some people just want them to be stricken from the record. So what will happen is the county has a request form to modify like every section of that condition, covenant, restriction, and then they'll re-record it so that in the future you will never see those words again. So that's a kind of a more recent law, and I've never really noticed anyone try to modify CCNRs in that way, but it is a possibility now to do that. Also, CCNRs are very important to look closely at. So if this was your prelim and you see CCNRs, there's typically always a hyperlink to the documents, and these are the ones that you want to click on. If they're really old, you may not care to look closely at them. I wouldn't say it's a big deal. Sometimes they're written in longhand, like handwriting, and they're very hard to read. It takes a long time to read what they are. But if you're buying a condo or a home in a private community, this is a guide for how you can enjoy the property or not enjoy the property. So your clients should, it should be printed out. They should look closely at it. It is going to have a lot of language that they may not understand, but they should just look at the index of each section. And if something stands out, like, oh, I want to know about how I can enjoy my balcony or that common area, like what does it say about, how many guests can I have, things like that. You may want to read through it. It may also say things like you're not allowed to have a short-term rental in this community, or there's a lot of very specific things in there. And it's kind of like buying a car. If you want to know everything about the car and how it functions, you should read through the CCNRs for your condos, for your private communities, or sometimes new single family communities out in the Inland Empire. They all have these CCNRs. After that, we have number 8 is a deed of trust. So in California, this is the actual name, the official name for a mortgage. So we always talk about mortgage and mortgage brokers and things like that. Well, there's actually no such thing as a mortgage in California. The term for it is deed of trust. And the deed of trust is that, the borrower is called the trustor, and then you have a neutral party as a trustee, and then you have the lender is the beneficiary of the deed of trust. And this is where they're holding trust that the borrower is going to follow all the terms of the loan. So that's why we call it a deed of trust. And so you're going to see only the principal, the original principal amount that's owed. You're never going to see how much is needed to pay it off. And a lot of people call me and they say, how much do they owe on this property? I really get calls where they really want to know how much is owed. It's not possible to know. It's a private detail. So the amount that's owed on a deed of trust is it can only be known to the borrower that's making the payments and the lender, until they authorize someone else to call and get that amount. And that's going to happen in escrow. They're going to give escrow the authority to call on their behalf and get a payoff demand. If you are working with the seller and you're trying to help like calculate what they might owe, ask for their mortgage statement, or we have a calculator that you can estimate what they might owe, but you cannot know exactly how much they owe. And under the deed of trust, you'll see anything affecting the deed of trust. If the property, if the borrower was behind in payments and they went into a pre-foreclosure situation, everything's going to show here. And so we have some stuff listed here. I'll get into briefly what it means. So under that, it says the trustee in said deed of trust was substituted by an instrument. So that means that the document is titled substitution of trustee. Whenever a substitution of trustee is recorded, that means that they're changing who is servicing the loan, who is sending out statements to the homeowner. And often it's a sign that either the borrower has been behind in payments, not always, but it's often a sign that the lender thinks they could be going into foreclosure at some point. Maybe they missed one payment or a couple payments. And right away, the servicer will change because the lender wants the servicer to be one that specializes in foreclosure processing. That becomes the new trustee and the new servicer. That's why it's called, some of these companies, they're called like trustee services, right? So the trustee services gets on board to start processing pre-foreclosure. And then we have here, it says there's a notice of default, right? And then even below that is notice of trustee sale. So these are also pre-foreclosure documents. The substitution of trustee is not always for pre-foreclosure, but it's often a sign that the lender thinks it could come up. They're preparing for it. Notice of default is recorded, and you have 90 days from that point for a notice of trustee sale to come out. It's all on a specific timeline. Even if it's a private money lender and they're in California, they have to go by the timeline. They have to serve notices saying you're behind 30 days, 60 days. And then they say, okay, they tell you we're going to start the pre-foreclosure process. And you'll have a new company to call in regards to your mortgage. So like going back, notice of default, again, it's 90 days after the notice of default is recorded to when you have a notice of trustees sale recorded. The notice of trustees sale is the official, it's the official like recording saying that there is going to be an auction. And the auction has to be no less than 21 days after the recording of the notice of trustees sale. Yeah, exactly. It's typically 21 days after the recording of that, but it can't be any less than that. So you always have this timeline of 90 days and then 21 days, but in most cases, it goes even slower than that. It's not the notice of trustees sale is not always recorded right away. Sometimes the borrower is trying to catch up. They may be making a payment plan with the lender. But if it is recorded, that's very serious. If you're in escrow and there's notice of trustee sale recorded, you have a limited amount of time to close, right? And you also cannot close if you're within, a week of the foreclosure. The title company and the escrow company are at risk if they close at the same time as an auction, or an auction could happen the day before, the day after, the day of, when you're trying to close. So title companies need to know that you have postponed the auction. And typically, if you're in escrow and the property's in foreclosure, the lender they will postpone it because they would rather get paid in full than carry the liability of this property in most cases. If you have a private loan and the lender really is eager to get that property, maybe they won't work with you. But I would say 9 out of 10 cases, the lender will work with you. They'll postpone if they know that they're going to get paid in full. So you need to tell them that you're in escrow and watch out for these auction dates. Make sure that they are being postponed. And then we have the next page, we have 9 and 10. It's showing 2 more deeds of trust. This means they have a second and a third deed of trust. These are going to be in chronological order. And so if the second was foreclosing, it would show it here. It's important to know that in foreclosure, there is what we call in lending, there's what's called priority of lien priority, right? And this is a big part of title insurance, why the lender gets title insurance. They want to know that they have either first position lien priority or second or third. The reason for the priority is if the second or the third is foreclosing, the liens that have priority stay due. They don't go away. So if you bought a property at an auction for a second or third lien foreclosing, you would take on the responsibility of the first, and you would consider that you need, often those don't sell, but if you pencil out the numbers, someone might want to buy it, but then you have to now pay off that first loan, right? So we show them in order, and if there ever was a change in the priority, we would have what's called oh wow, I'm drawing a blank. It's not on there. Um, there's a document recorded that changes the priority. Sorry guys, I can't think of the word at the moment. It's really bad. I'm presenting this. It'll come back to me. But we have these mortgages here. And then number 11, we have a judgment showing, right? So what happens if you see a judgment on the prelim right when it comes out? Sometimes the judgment might not be actually your client's judgment because people they have sometimes common names or names that are similar to others. And if we're showing the judgment on our report, it means that we believe there's a strong chance it could belong to the owner of the property. But don't jump right away to show this to your owner, your seller. Sometimes it could be alarming to them if it's not them, especially this one. So this is a support judgment. I don't know if I need to zoom in for you guys to see it, but this is a child support judgment. Child support judgments do often take about 2 weeks to get a demand for them, depending on what county it is. Sometimes it takes a good amount of time. So how we would clear this up, we always need what we call the statement of information, or my company calls it statement of facts. This is where the homeowner is going to explain that they have lived in certain addresses in the last 10 years, employed by certain employers, who they were married to, if they're divorced, their social security number. We really only need the last four. With all these things, we can look and confirm whether the lien belongs to that person or not, and maybe even find if there are any other liens. So any lien that's a personal lien, like a judgment or a tax lien, like a IRS tax lien or state tax lien, we need the statement of information in order to know what liens they have. So the sooner you get that to us, the better. We always recommend that it's filled out at least right when escrow opens. If your client is kind of being candid with you and they say, I might have a judgment or I might have a lien, you can ask them to submit it to us earlier than escrow opens so that we could try to clear their name ahead of time. Because some judgments could take a long time to clear up. If your client filed bankruptcy in the last 10 years or so, it's also good to have us run their name right away and clear that statement of information. Bankruptcy is a big red flag, because a judge in bankruptcy, bankruptcy court is typically the most common bankruptcies. They're going to help you clear these unsecured liens, these credit card liens, these auto loans, and sometimes judgment liens. But there's an extra step that a bankruptcy attorney has to go through, and the debtor, like the person going through bankruptcy, has to request this extra step. So they have to, if they do have a judgment against them, and it can't be for a child support, but if they have a judgment from another creditor, it could be related to one of those credit cards that the debt was discharged, but the judgment still needs to be paid if they didn't get what's called a motion to avoid lien, and it's a separate process. So they will literally have to go and reopen the bankruptcy case if they did not do that, if they did not follow that step in the past. So I don't think your seller is always going to tell you I filed bankruptcy, but if they did, if they own small businesses, if they've been divorced, or you see these things, you may suspect that there's a possibility they had a bankruptcy. It's good to ask the title company to look through their name for liens, and also just submit that statement of information so we can find it and clear it up. And then on the next page, we have, okay, I'm showing you there's a lien from the United States of America. This is a tax lien, of course. These are typically easy to get a demand for. It's not a big deal. We can clear that up in escrow. But again, we need the statement of information to clear that up. And then right here, item 13, this is, like I said, way back on Schedule A, it said subject to, and it was item 13. And we show the effect of a conveyance of land. And prior to this transaction, we will require evidence of validity. We always want to make sure that the transfers were valid. And why do we do this? Even though the client tells you, oh yeah, it's my brother, he gave me the property, or so-and-so they just gave me the property, and they don't want to explain why. Okay. If somebody did gift the property to someone else, we don't know that they didn't have some verbal agreement or off-record agreement. There could be, in some cases, agreements where when the property sells, they're going to get some of the money. Or we don't know if the deed was signed under duress, or we don't know if the deed was signed by someone who doesn't have mental capacity to sign the deed. There's a lot of things we don't know. And as a title company, we consider all of these risks. So we want to make sure, once more, for the protection of everybody in the transaction, that that deed was valid. And in most cases, they're very simple. They're never really questionable. If you have some case where it was a divorce, we could rely on a court order showing that the property was awarded to one of the parties. We don't always need the ex-spouse to come into the mix again. So anytime there was a court order involved, that could be a supporting document in lieu of getting the person to sign. But it's all case by case. So if you run across a uninsured deed on your report and you're not sure if you're going to be able to clear it up, bring it up right away with your title rep, your title company, and try to figure out a way that you can clear it up. Number 14, we have a financing statement recorded, and it says the secured party is Solar World. So obviously this means that there's some kind of solar power on the property. But when we have a financing statement, it's also called a fixture filing. This typically means that the solar equipment is leased and not owned by the owner of the property. So that means they have solar, the equipment is leased, and that lease agreement needs to be transferred to the next buyer. So it's also something that the seller needs to get moving on, and they should contact escrow right away if they have a solar agreement, and especially if it's a lease, because the lease is going to have to be assumed by the buyer, right? Or maybe the buyer doesn't want the solar panels and it's got to be undone during escrow. So these are things that take time. Number 15, it says Solar World in or to the solar energy system, land. It's a solar notice of independent solar energy system producer contract. So the solar contract is going to be recorded regardless of whether it's a lease or they purchased the property, the equipment outright. The reason for this is because the solar energy contract has terms of the warranty for the equipment and all this stuff. It's not a lien. It just means that there is this contract with the owner of the property. And even if the property was paid off completely, the solar contract needs to be assumed by the new owner, whether there's money owed or not. It needs to transfer over because they may have a warranty for 20 years and they've only had the equipment for 5 years. And the new buyer is now going to need to be able to call in and say, hey, I'm the owner of this solar equipment and it needs to be repaired, etc. So all of these things need to be assumed by the buyer, and it takes time. It needs to be dealt with right away. And then moving on to item 16, So it's saying the requirement that we furnish a copy of the Doe Family Trust. And so you definitely want to take some notes here. The family trust, when the property is in the trust, the only time that we're going to request a full copy of the trust documents is if the original trustor or original trustee has deceased, or they're mentally incapacitated, meaning they can't make decisions. Why we request this is because we need to see proof that the new trustee is who they represent themselves to be. If there's multiple trustees that need to sign, sometimes trustees need to sign like together or in order. If one steps down, the next one takes it on. We need to see proof that the correct person is signing as the trustee. But in many cases, if the owner is not deceased, or it's the original creator of the trust is still signing, we only need what's called a certificate of trust or certification of trust. And it has to have the California California legal code on it. Sometimes people go out of state to create a trust. That's a bad idea. You should always work with a California attorney if you're dealing with property in California, because the laws are very state to state. Some attorneys in other states will create trusts that don't apply property to California law, and it could be problematic for the transaction. Um, if you ever see something called a land trust, that's a big problem. That's a huge, probably the biggest red flag ever on a report. A land trust is it's a type of trust where there's typically many beneficiaries behind, like it's like an investment strategy, and you could have like 200 beneficiaries behind that trust. Title companies won't insure it, and in California, land trusts are just not recognized as a legal way to hold title. So looking out for that type of trust. While we're on the topic of ownership, what is the question that's in there? Or is there a question phone? I don't want to lose the screen again. Well, okay, so if the party is passed away, then we would want a copy of their death certificate to prove that they passed away, first of all. And depending on the timing of how long ago the deed was recorded that they transferred it, like if they died weeks after transferring the property to someone else, most companies will not accept that deed, because we don't know if there's someone else out there that thinks they were supposed to get the property from them. It's kind of a big risk. But let's say the deed was recorded 10 years ago and the person died. We may ask, can you supply if there was a will of some sort? But it's up to the discretion of the title company to decide if they want to take on that risk of that uninsured deed and the person is deceased. But typically, like if it was done right before they died, you're going to be asked to go to court for probate in a lot of cases. Most title companies won't accept that deed so close to the time they died, unless you can provide some really like supporting evidence. In some extraordinary cases, a title company might allow you to have all the possible heirs come and sign something agreeing they're okay with the deed. But you have to really discuss it with your title company you're talking to. Sometimes you have to go to several title companies to get to know for sure. If they're ever telling you have to go to probate, you should always talk to 2 or 3 title companies at least, and just make sure no one will accept it. But in most cases, they won't. If the person is missing completely, that's also like a really extraordinary situation. Um, it's also going to be a similar thing. Like we're weighing out the risk. It's up to the title company's discretion if they want to accept it or not. But I think you'd have to prove that you went above and beyond to find that person. You've given maybe everyone in like the escrow or the agent involved like as many phone numbers and past addresses as possible. If someone's completely unable to be found, it's again like they're weighing out the risk, and it could require you to go to court depending on how risky it looks. And if you had to go to court, you would need a court order. It's called a quiet title action that would then a court order would vest the property to the owner that it was transferred to, however they decided in court. There's 2 more things in there. on the- Oh, okay. So, and then, I want to go back to the ownership while we're still on 16. Um, another, something you may want to take note of, if your property is owned by a corporation, like an INC Inc. or an LLC or a limited partnership. So for a corporation, we're going to ask for what's called the articles of incorporation. Um, and then if it's an LLC, we're going to ask for the LLC's operating agreement with list of members and bylaws. These operating agreement and articles of incorporation, they act similar to the trust agreement. They're going to outline who gets to sign on behalf of the entity. Um, and they may say that, so many members need to decide whether we're selling the property. Title company needs to see that because it's not a public record. We can't look up the operating agreement or the articles of incorporation. Sometimes it's on the state website, but we also can't rely on that because we need the parties involved to say, this is our current entity operating agreement or articles of incorporation with meeting minutes and any amendments and changes. We don't search for this stuff because we could be missing a recent change that's not reflected online. If the company is if it's an LLC or corporation, the question was, how do we show? So we don't update the report to show who's going to be signing. We review those documents. You tell us who you have as your signing party, and then we review the documents and we come back to you and you say, yes, we approve of that person being the signing party or the authority to sign. When it's a trust, if someone's deceased, we do like update the report actually to show the successor trustee once you've provided the supporting documents. But for an entity, we don't make any changes to our report. We just need to be satisfied with what you provide to us.
How do you address if the sellers pass away in the middle of a transaction? Thank you.
So the question was, how do we handle it if the seller passed away in the middle of the transaction? I mean, you have to consider first your contracts that you have will take precedence over anything going on with escrow and title. You have a contract signed by someone who's deceased. So you are going to need to probably cancel that escrow. Or unless the parties agree, like we need to see, who's going to take, is there a success? Is it in a trust? Is it in an entity, or how did they own it? We don't, if there's not an automatic succession of ownership that we can put together with what we have, sometimes the escrow may need to be canceled and start over, and you would obviously need to start with new contracts, right? You would have to amend all your contracts to show, we have a different seller now. So yeah, I mean, that would probably just, I think I've seen that happen once in the past few years. And I think the escrow just fell out, and it probably, because it's going to take a while to put that all together. You can't just move on with selling when you have to deal with estate issues like paying off debts and all kinds of things. So, I mean, I think that would really put a halt to the transaction unless it's just like a joint tenant taking over and continuing to sell. It really depends, but we're going to need to wait for that death certificate so we could see that, have proof that they're deceased. So it could add a couple weeks to the timeline. Yeah, there's a lot of different scenarios that could come about with that.
Thank you, Joe. Going back to your easement earlier, so if you have an easement for your utilities, can you request to have it like vice versa if it was above ground to move it underground if you want to build ADU, or vice versa if underground you want to move it above ground? Can you ask like the electric company or the gas company or the phone company to do that? Thank you.
I mean, you can always ask. I don't know the answer as to like whether they will do it or not. But that's why it's good to look at the easements, because you would have to wait till you close escrow and become the owner of the property, and then you would have to So it's good to see the easement so that you know where everything is. But yeah, that's after close of escrow kind of scenario. So it's hard to say whether the electric company will move their wiring or relocate the easement. But it's definitely possible, and they could change the easements that are of record. 17, I didn't touch on that yet, but so that's where we're always going to have this item if unless we're confident that there's no liens against the owner, which sometimes we are, like if the name is very uncommon and we're able to just see it. We don't always add this item, but this is just saying that there are possible liens that we need to clear up before close of escrow. And so once again, if you want, if in order to move forward with the loan process and everything, this item needs to be cleared. Again, we need that statement of information right away when you open escrow, and if possible, sometimes before opening escrow, it's good to have it ready. Again, on this report, we have, I'm gonna rotate this. We have the assessor's map. Locating the property on the assessor's map, I'm just gonna briefly explain. So up on the top, you have the book and page number where it says 1 and 2. This is all coordinating with the assessor's parcel number, right? So that the bigger number is the book and the page number. And then on the plot map or the assessor's map, you have the circled number. That's the last 3 numbers of your APN. So that's kind of how you will find it. But you could also see there's the uncircled number. That's the lot number of the lot of the tract that it's in. And all of that can be, if you go back up to Schedule A, you'll see the parcel number, you'll see the lot and tract, and you'll be able to find it. If you ever see dotted lines next to around your property, that could be it's not always a concern, but it often means that the lot the lot lines were adjusted at some point, or if your property was cut out of a larger lot, it may be showing as dotted lines, right? If you ever have questions like on a really specific, details on some map, you can always come to me later. This is a pretty basic map. You also have square footage of the lot on the map. And that's never like an absolute accurate number. It's always what the assessor comes up with. So the title insurance doesn't protect you if the lot is somehow a couple hundred less or 20 square feet less. We don't cover the exact size of the lot. But it is basically a rough number that's on there on the assessor's map. And I see there's like a question. Let's see. Are we able to receive a copy of the PDF? Hey, Alex, yes, we are going to share the PDF of this presentation. So, you know what? Actually, I would like it if you guys just shoot me an email and I can send it. I'll send it to anyone who sends me an email to ask for it. So you could see my emails right here. Or you can send me a text, but I'll need, if you want it texted to you, I could do that. Or you could email it to you. Here's my email address, joeh@octitle.com. You also have my website here. If anyone needs to sign up for my online services, you can go there. And that's the end of the presentation. I don't know if there's more questions before we wrap it up. Thank you, Alex. Appreciate it.
Okay.
You have a question?
Are you taking another one?
No, there's no more,
Okay.
nothing showing.
If there's 3 APNs involved in one sale and it
Mhm.
was sold that way, how is that handled? It's 3 separate APNs, but it's only
In one
one
sale.
owner. Yeah.
If we go back into the report in schedule, we're gonna list all of the APNs on this first page. We're gonna list all of the legal descriptions, and we're typically gonna we're gonna refer to each one as parcel 1, parcel 2, parcel 3. And then when you get into Schedule B, where under each item, it's gonna say, this item affects parcel one or parcel two or parcel three. So we'll actually be mixing it all into one report, everything under Schedule B, and we will try to, it will typically be still in chronological order, but you know, a lot of times when parcels are sold together, they also typically have a report that's uniform, like they all have the same lien, the same owner.
Mhm.
But yeah, we do just combine it all into one report.
Okay, and if I don't see that, then what I
Then,
need to ask? for?
yeah, you
Okay.
should definitely let escrow know, hey, we are in contract for, you know, show them again the contract. The contract shows these three parcels, and if the contract is not good, you should also update the contract, but make sure they know to reflect all. Typically, title companies will, when parcels have been historically held together, when we look at one, we'll see the other parcel numbers on the deed and things. And at the order being opened, at the process of the order being opened, we'll know that there were other parcels connected to that one. And we'll often ask right away, hey, we want to make sure there's these other two parcels. So that usually the title company will catch it, but you definitely should ask if you don't see, ask them to fix that.
Because when I pull the property profiles, I had to go in with three APNs and
Mhm.
everything was separate and then reference each other.
Yeah.
And as far as the three APNs, and it didn't show the second owner on there. And I
Mm.
called the title company and they said, oh yeah, they're here. It's just
Mhm.
not showing up. But will the preliminary report have all should they show everybody?
Yeah, I mean, unless like in some cases there were the uninsured deeds, so you may not see the current ownership right away, if there were uninsured deeds, but if all the deeds were acceptable to the title company, they should show them. And if one parcel has an extra owner, they should have separate ownership listed in Schedule A for each parcel, you know, and they'll say this affects parcel one, parcel two. So it should be very clear in the report.
No more questions? I have one, Joe.
Oh,
Quick question. What does it mean when there's a cloud on title?
yeah, so a cloud on title, it could mean a lot of things, but it generally means there's something affecting the property, like a deed or a lien, or it could even be that there's like maybe a notice of lis pendens, that which means there's like a current court, something going on in court. There's something affecting the property that cannot be cleared up or that's difficult to clear up. So it's not, a cloud on title is not like necessarily a very specific thing. Like it's a deed recorded that we can't clear up, but it's often like those questions you were asking me, if someone was hard to find or they died, and we're having trouble clearing up the evidential proof that the transfer is valid. So that's what the cloud generally just means, that there's some challenge related to what's on title. There's another question. So another question in the chat is, if there is a CCR recorded long time ago and the restriction is no longer valid, how can the buyer and seller get it removed? What if the party involved has passed away or no longer to be found? Well, so the parties that create the CCNRs are not needed to do this. Sorry, I'm gonna Google restrictive modification. So it's called a restrictive covenant modification. It's under Assembly Bill, or AB 1466. So AB 1466, just putting that in the chat. If you search AB 1466, there's a form that the LA Recorder's Office has that you can complete, and you can submit it. You don't need to be an escrow to do it. You can submit it to the county recorders saying you found something maybe it's on your title policy, and you have the CCNR where it says something you don't want. And you want it to be removed, you just complete the AB 1466 restrictive covenant. And there's a fee for it. I think it's like $13 or something to get it recorded. But yeah, they will basically pull up restrictive covenant, and they will redact the lines so that in future times when it's pulled up, it'll be blacked out. That's basically all they can do. Without, because they can't remove the entire CCNR because it could have something that's not part of the restrictive covenant modification law. It could have something that's still relevant, right? So they go and they just redact what needs to be removed. And yeah, and if you want to do that in escrow, let your title company know because it could be submitted with the escrow with the closing documents. And Joyce says, is the legal description always correct? That's a great question. In some cases, the last deeds, sometimes the deeds have been recorded with incorrect legal description. Anytime the legal description is found to be invalid or incorrect, the LA County or depending on what county you're in, the assessor's office reviews every deed that goes through, and they will send you a letter. I think it's usually on yellow paper, and it will say, we found this deed recorded by you to have an invalid legal description. They will let you know, and they will want you to correct it. If you closed escrow and the title company and the escrow were responsible for recording an invalid legal description, you should go back to them because essentially it's a title claim, a claim of like the insurance, even though they're not gonna, you're not losing money over it, but title company is gonna be responsible for re-recording the deed, paying for the recording fee. You should not have to pay for anything. You have the title insurance. So anytime you find some invalid, something that you're unhappy with on your title, go back to the title company, they'll fix it. Also, title insurance covers things that prevent the property from being marketable. So if there was this legal description issue or something showing up on your title, definitely go back and try to file a claim with your title company. Yeah. And I think that's it. I don't know if there's any other questions. You guys can you can email me, and please email me if you'd like a copy of today's presentation. And it's being recorded, right? So it's going to be.
Yeah, great. So I want to thank Joe Haggerty for coming out and giving us his great presentation. And I know he has a busy schedule. Really quick, I would like to, everybody that's on Zoom and live, please, don't forget Gov Hutchison, Thursday, July 18th from 10 to 11:30. It's hybrid, live, and Zoom. Please sign up. Please sign up. So again, I want to thank Joe for his time. Great presentation. And I want to thank everybody on Zoom and our great live audience that we had today. Joe, thank you. And in appreciation, I'd like to give you this certificate as part of our education committee. Thank you very much. And thank everybody on Zoom and live. Thank you.